Can
you all hear down there?
Can you folks hear me in the back? You can't hear me?
Can you guys hear over there?
Okay. Okay. So I'll do my best to speak loud and clear, okay? So my name is Rick Miller, and I have a financial planning practice in Arcadia. And today are other clients that are not affiliated with my practice, because I partnered up with a number of other financial planners in Southern California that I've met who have Woodbridge note holders. So Pam is here, and Carolyn and Sam and Ray have all reached out to their clients so that we could have a discussion today and get some valuable information as to where we stand with Woodbridge and their money, okay? So what we're going to do is we're going to go straight through the program. If you feel the need to use the restrooms, I've already announced it 3 times, they're over here to the left and to the right. Would everyone take out their phones, please, for me right now, and just put them on vibrate or silence. Thank you for doing that. So I mentioned earlier, most of you parked on these grounds here, right? Most of you parked here? Okay. And then I mentioned that the fee today is just $12 for parking, but Sandy's going to pay for it. Okay, so that's good. And Sandy paid for the coffee and the pastries. Thank you, Sandy. All right. All right. I'm also going to be recording today's presentation. So anybody who would like to get a copy of that, just let me know, and we'll make that available to you. And I have a number of clients that couldn't make this meeting, so obviously we're doing it for their sake as well. Okay?
And for $12, I'll actually sign it for you.
Okay. Thank you, Sandy. Okay. So let me outline for you, I think, the objective of today's meeting. We all have questions we want to answer. That's probably the most important objective to accomplish today. But Sandy's going to go over how bankruptcy works, the process, the timeline, answer some questions, fill in some details and some specifics for us. And hopefully we'll leave feeling more relieved and a better understanding of what's going to happen in the future and how soon we'll get our money back, okay? So what we'll do today is we'll break it up into 2 parts. Part 1 is Sandy will speak and give us an overview. He'll take anywhere from 15 minutes to 30 minutes to fill in some loose ends and some details. But the better part of the meeting will be a Q&A, questions and answers, okay? So we want you to feel engaged, take notes. There were handouts. You guys got handouts. Does everyone have a pen and a pad to write down notes? Okay. Anybody need a pen or a pad? All right. So after the debacle on December 5th with Woodbridge, quickly I started looking into legal advice as it relates to you folks. And that's when I found some other financial planners that were equally in the same situation. And there's a bunch of my friends in other parts of the country that are also in the same situation. But we started scouting out law firms and attorneys that we could interview and find out what they knew and their expertise and what they could bring to the table to help us all. And so today we have one of the lead attorneys in the bankruptcy department over at Leach and Tisch. We have Sandy Frey, and Sandy's going to be speaking today. He's our speaker. He has an expertise of over 30 years in bankruptcy, representing both sides of the table, as well as real estate transactions and a couple of other fields. And of course he has a whole team. And this is currently his temporary Pasadena site. They have a bigger office in LA, which they prefer him to go to, but he'd rather drive to Pasadena most days. And they're relocating to a new office in Pasadena. Get all that right?
Yes, you did.
Good. Now, we probably don't have enough brochures for you about his firm, so if anybody needs his resume and the brochures, just let us know before you leave today. We have some clipboards that you guys can fill out before you leave today, because Sandy's going to propose to you the possibility of retaining his company to help you in this matter. There's no pressure to hire Sandy's company, but the more people that are on board with legal advice and help, the lower the cost will be for everybody. But I'll let him explain that to you in more detail because he's the expert. So would you guys give me a round of applause for Sandy first?
Thanks everybody for coming out. You can hear me?
Yes.
Yeah? All right. Thanks everybody for coming out on the weekend and sitting and listening to this. I know it's painful enough, and now to have to listen to me, it's even more painful. I have just my least favorite subject, me. I've been doing this for actually about 35 years. I don't do anything else but bankruptcy law. I represented Paramount in the Marvel Comics case. I have represented IBM in the Prentice Copley real estate debacle. I have represented Donald Trump's golf course, Ocean Trails. We reorganized it. You can hear me better? I was Creditors Committee counsel in the Namco Capital case, which had actually a lot of the same lawyer players that are in this case, so we all know each other. And I've also represented, believe it or not, reorganized the entire International Society of Krishna Consciousness, So I won't go over all 35 years, but I started my career in bankruptcy as a staff lawyer for one of the bankruptcy judges, then ran a bankruptcy group for a national firm, boutique bankruptcy firm for about 12 years, and then I joined Lee Tishman. We have a full-service firm. We have a large bankruptcy group, and we have offices. Our main office is in Pittsburgh, and we have Los Angeles and Pasadena, and actually a new office in South Bay, Delaware, which is critical to this case, New York, Chicago, and a bunch of other places. As Rick says, I'm going to do some brief overview, and then I'll take questions, because I'm sure a lot of you have questions. Hopefully I'll address some of them. I can't address everything, because there's a lot of still unknowns in this case, because it's relatively early. But if you take nothing away today, because of the uniqueness of this case, you should take away, whether you hire me or some other bankruptcy lawyer, you really should get personal bankruptcy counsel at least as a group, because what you're looking at in terms of the committees are not going to be able to adequately represent your interests, and I'll explain why as I go on. And it should be a bankruptcy lawyer, because bankruptcy lawyers, we all know each other for the most part. We've all been doing this together for many, many years. We know the system, and we're more recognized in the courts, and we know where to take the case, rather than some other type of lawyers. And most of my referrals, not unlike this case, come from other lawyers who come to me for the specialty. These cases move very fast in terms of what's happening. Already in this case, in the very brief time it's filed, there are already a docket entry as every time a pleading gets filed, it gets entered on the docket. There's already over 400 filings in this case that I have gone through. Interestingly enough, I would have expected it to be further along than it is right now, which indicates to me that at the pace it's moving, there wasn't a lot of pre-planning. You don't just file this case in one day on a case this size, but oftentimes I'm working on a case before we file as much as a year, and that doesn't appear to be the case here, because there's still a lot of early things that are going on, jockeying for position, that normally I would have seen would have been resolved before we get to this point in the case. And you know, my firm generally monitors what's the jungle drums out there, because we want to warn our clients if there's a problem coming up. And I heard nothing about this. I was surprised when it filed. So if that tells you anything. I want to talk about a little bit, because I tend to say debtors, creditors. I want to kind of just go an overview a little bit of the various constituencies in the case. The debtor in this case is Woodbridge, and we refer to Woodbridge, but it's actually not a debtor. It's 138 debtors with 138 separate properties. Before the filing of the case, they appointed a chief restructuring officer, Larry Perkins. Larry, I know very well, is a chief restructuring officer. That's what he does. So from the time he got appointed, they already saw the cards were on the wall that they were going to have to file. I haven't looked at when he got appointed, because I can't tell from the record, but it's something interesting to look at as we go down. Usually a CRO is appointed because I'm worried that I'm going to file a case. When you file a case, you get the debtors are what they call a debtor in possession. They're effectively a trustee in the case. They now have a fiduciary duty to the creditors. If I'm putting a CRO in, I'm a debtor's counsel, it's usually because I'm worried I'm going to get a trustee appointed, an independent trustee, because there's some grounds for appointing it. Those grounds, gross mismanagement, various grounds. So usually I want to put that in. I have some concern, so that's why they're there. Then there's administrative creditors. Well, you got secured creditors, then administrative creditors, Administrative creditors include professional fees. Then you've got trade creditors, and then you've got the note holders, which are also creditors. You folks are creditors in the case. But you're distinct and different from the other unsecured creditors, and I'll explain why. Now, to give you an idea, the creditors committee, I talked about committees in the case and why they can't adequately represent you. So let's talk about the unsecured creditors committee. They consist of 3 people. One was a trade creditor, and 2 were note holder creditors. In order to get on the note holder, creditors had to waive their security interest to get on the committee. I would never let my client do that. And that was a prerequisite. So you basically got 3 creditors on the creditors committee, all of whom are unsecured. So they can't represent your interest if you're going to be taking the position that you're secured creditors. And then you've got in the case several groups of note holders who are represented by various lawyers on different groups in the case that have taken positions in the case. One thing you don't want to do is sleep on your rights, and that's why I'm advising you to get your own lawyer. When I say your own lawyer, I mean, it could be a lawyer as a group, but somebody who represents your interest as opposed to the committees. By way of example, right now I've got a case going on where it ended up, after they filed the plan, it was 100% distribution to creditors. But a whole group of creditors that were told by the debtor, don't worry, didn't do anything about it, slept on their rights, and didn't notice that there was a little teeny box on the schedules of assets and liabilities that the debtor filed originally in the case. And that little box said unliquidated. Well, if it says unliquidated, that means you have to file a claim in the bankruptcy case. They didn't file a claim. The rest of the creditors all get paid. Now they came to me and said, what can we do about it? And we're doing something about it, but the cost of doing what I'm doing now is going to be twice or worse than if they did it right in the first place. So that's why I'm telling you, you need to look at this. And it's not, filing a claim in the case is not as simple as just filling out a form. You got to have proper documentation. You want to make sure you're filing the claim, designating yourself to the right class. The problem in this case, why it's unique and why I say you can't really rely on the committees, is because there's no unity of interest among the note holders. You've got, in a bankruptcy case, secured creditors are paid ahead of unsecured creditors, so it's always better to be secured. Some of you are going to have, I hope, validly secured claims. Others of you may not. And when I say secured, security has a different meaning, somewhat different meaning in bankruptcy, because you may be secured versus the debtor because you've got a security interest. But when the debtor files a bankruptcy proceeding, that debtor, Woodbridge, stands in the shoes of a trustee. That trustee has certain rights of certain types of creditors and stands in their shoes. So if it's not properly perfected, even though you got a valid security interest, it doesn't necessarily mean you're going to be secured for bankruptcy purposes. And this is going to be one of the key issues in this case. The creditors committee, the general unsecured creditors committee, are going to want you unsecured. Why? Because if you're unsecured, you share pro rata. Now that doesn't necessarily mean anything if it's a 100-cent case. If everybody's getting paid, who cares if you're unsecured or secured, because you're getting 100-cent dollars. If, on the other hand, there's a shortfall, you're going to share pro rata with every other creditor that's in the group, and I'm going to get to that in a minute because there's a unique thing, another unique thing about this case. The unsecured note holders in the case that have no security are also going to want you unsecured, right? Because why should you get paid as a secured creditor if they're unsecured? So there's this tension in the case that's going to be an issue coming down the line. And then, as I said, you've got 138 separate debtors and 138 separate pieces of property. So one entity, one debtor may have more value than the next debtor. The group that you're in may have equity in it, whereas the group that note holder B is in may not have equity in it. You don't want to be sharing pro rata, and then there's another nuance in this case, because as we talked about, it says 138 debtors. Well, you look at the docket, it's under one case, Woodbridge Group of Companies. However, that only means it's jointly administered right now. That only means that if I'm hiring one lawyer for 138 companies, I don't have to file 138 of the same pleading. I can file it in one case, and everything is in one case. But legally, they're separate entities. So this could actually work out if you're in a group that the property is very valuable. This could work out to an advantage to your group because your asset may have value. What you don't want to have happen in this case, and there's been discussion about it, I've seen in some of the pleadings, is a substantive consolidation, which is where all the entities are then treated as one entity. And I say it doesn't appear that we want that at this point. I don't know. If we all end up unsecured, you have to look at the assets, liabilities, and that's not a cheap piece of litigation, but it's something that I envision is going to be coming down the line. So a lot of that is going to depend on the value of the assets and the amount of claims and whether you're secured or unsecured. And even if you're unsecured, if that particular entity has value above the secured debt, you're still going to get a sizable distribution, whereas others may not. The committees, they have to operate for the benefit of the constituency as a whole. So the unsecureds are going to operate for the benefit of the unsecured creditors. They're not going to take the position that you or you or you were secured. Similarly, there's an ad hoc committee of note holders, and I'm going to get to that in a second, that was formed, which is a hodgepodge of different creditors in that case, in that committee. And ad hoc committee is a committee that's formed not by the bankruptcy code, but by for a specific purpose to represent a specific group. That ad hoc committee is not necessarily representative of your interests. It was appointed by virtue of a term sheet, and I'm encouraged by the fact that they reached a term sheet in this case, but the formation of the committee was a trade-off. What had happened was the Security and Exchange Commission and the Unsecured Creditors Committee filed a motion to appoint a trustee. Why did they file a motion to appoint a trustee? They alleged that there was, it may be a Ponzi scheme. They alleged that there may be, that Shapiro's still involved in it, and that the management that was appointed was still handled by Shapiro, and that the board of directors was still under Shapiro. So they brought a motion on. That was opposed by the three different groups of note holders opposed it. And what they astutely pointed out was there were allegations, but there was no actual proof of any of the things that were put forth in the pleadings. And so therefore they said, you know, we don't want to have a trustee in the case right now because it's going to add another layer of expense to the case. At the same time, the SEC, one of the committees was trying to form this ad hoc note holder committee. The SEC said, well, the note holders should be represented. They opposed it. This group doesn't represent the interest of the entire group. And the Unsecured Creditors Committee opposed it on the basis that they're on the same basis. Now, I'm going to read you something so you don't have to take this for what I'm saying at face value. This is from the opposition by the Unsecured Creditors Committee to the motion to appoint the ad hoc committee. There is no unity of interest among the note holders. Instead, each note holder has a security interest in the note holder collateral that relates to a specific ProCo or MESCO, and therefore can only represent the interests of such note holders as such particular PropCo or MESCO. Thus, the recourse of each note holder is limited to his or her particular note holder collateral, and therefore does not extend to any note holder collateral regarding the 173 other PropCos or hundreds of pledged notes by the MESCO entities. There is no unity of interest among the various note holders because the note holder collateral exists only on a debtor-by-debtor basis and does not represent the collective claim of the note holders across the debtor's multiple estates. And then it goes on to say, while the note holder group and their counsel would like the debtors to finance issues that relate solely to the existence of their individual claims in the particular note holder collateral, there is no justification for the estates and the unsecured creditors to bear this expense. So this is right in the pleadings. Now what happens? Why does the note holder committee then get appointed? There was a term sheet reached in the case, which was compromised. It's like a bill before the Congress. I want X pass, so I'm tagging on Y because this interest group otherwise won't support it. So what ended up happening in the case, there was an agreement reached where there was no trustee appointed, in exchange for which the board of directors of the debtor is being reconstituted with 3 new members. And they agreed to have this ad hoc note holder committee with a limited cap on the amount of money that would get reimbursed from the bankruptcy estate. So in certain senses, that it's good to have a committee because when there's commonality of interest, you're spreading the cost among, and they're getting against the debtor rather than having to bear the cost yourself. But on other issues where there's no commonality of interest, you need to have yourself represented. Let me get to the issue of probably near and dear to your heart. How much am I going to get and how long? Right? That's the bottom line. And unfortunately, I don't have an answer for you. The reason I don't have an answer for you is early in this case, there's no schedules of assets and liabilities filed. You have to file in the case, the debtors, schedules of assets and liabilities. There will be 138 schedules of assets and schedules of liabilities filed. That will give a better sense of where the case is at. Remember I said earlier, the case is not moving along as fast as I would have thought, because usually you're doing that in the pre-planning stages. They're not going to file that. There's an extension to March to file those. So we're not going to know for a while what the assets look like. However, on the positive sides, I don't want you showing up on a Saturday and not giving you at least some sense here. On the positive side, I'm not seeing what I would call a true Ponzi scheme here, and I'm going to get to that in a minute. There's real property. There appears to be 138 pieces of real estate. We do, from the papers, I've been able to glean that the real estate's values are anywhere between $50,000 to $150 million. There's approximately $750 million in debt. The California real estate market, they're mostly in California, and the California real estate market is still pretty vigorous. The debtors allege that they're worth billions, but who knows? We'll see when the schedules come out. And again, you know, some investors may be better, some note holders may be better off than others, depending on which asset you're in. The other good thing, I've heard rumors that there's claim traders spinning around that are buying up claims. This is a really good sign in the case for me early on, because what am I looking at? And I did a reorganization / liquidation for a mortgage company not that long ago, where we had several $100 million of debt. We did it mainly as an out-of-court workout. We paid down a lot of the debt before, but $120,000 creditor, believe it or not, ended up triggering the bankruptcy filing. And we were at a point where we had all the difficult loans that we had to liquidate on the table. The long and the short of it is we confirmed the plan. Claims were being bought up at 25 cents on the dollar during the case. We have now distributed 75 cents on the dollar, and we still have more assets to distribute. And overall, between pre and post petition, it's going to be close to a 90% distribution in the case. So these guys don't buy claims for no reason. They're usually looking for a return. And the creditors in that, the claims traders in that case that bought claims are getting a 3-time return on their investment. So they did pretty well. Negatives in the case. There's a lot of expensive lawyers. I looked at the sign-up sheet for one of the hearings on January 10th, and I was mortified to see that on a 3-person unsecured creditors committee, I think it was 8 lawyers that showed up at the hearing representing these 3 creditors. And my firm, my rates are kept low, even though these are my contemporaries, because we're Pittsburgh-based and the rates are a lot lower. And even though we're a little higher in LA, we try to keep it coordinated. Some of these guys are charging over $1,000 an hour. Keeping lawyer fees under control in this case is going to be key. When I was in the Namco Capital case, I was creditors committee counsel. I was in the longest. My fees were the lowest, but I also objected and was an unpopular person to everybody's fees in the case. Not because the lawyers did a great job, and I will tell you, there's good lawyers in this case that will get a reorganization done. The problem is they're not cheap, and I said, you know, they all did a great job, but this is obscene. The lawyers are getting almost as much as the creditors are getting, and it's just not fair. So that's one thing that really needs to be tried to keep under control. I said one of the encouraging things is when I see the SEC, Securities and Exchange Commission, the Unsecured Creditors Committee, and by the way, some of the players in that, my NAMCO case are in this case, and the note holders all sitting down and trying to cut a deal to make, rather than going into hearings of war and evidentiary hearings, that's a good sign for the case. So it's encouraging. And you got also in this case an expensive CRO and a very expensive accountant. So that's going to be managing it. But then again, if you get a large enough return, just keeping the lawyer fees under control will help that. And that only matters, by the way, if you're unsecured. If you're secured, you're ahead of them. That's why that will become a key issue in the case. Ponzi schemes. I've heard allegations that from the SEC that this may be a Ponzi scheme. I've heard that in a lot of cases. I haven't seen, I've looked at the pleadings. I haven't seen any real evidence that it is. And I don't know if, does everybody know what a Ponzi scheme really is? It's essentially you don't have a core business, you're using investor money to pay investor money. I'm not seeing that here because first of all, you got 138 real pieces of property. They're there, so that's a good sign. You got assets. And it doesn't appear that it started off so as a Ponzi scheme because you had real legitimate business going on and real legitimate properties going on. And also typically, the Ponzi actions are against net winners in the case. Unfortunately, you guys are the net losers so far, so I don't think you have to worry about that while it's being bandied around. So, at least for the time being. Length of time. Really hard to tell because we don't know how all the issues are flushed out and we don't see a business plan for where they're going yet. I'm going to give you my best guess since you were gracious enough to show up today and listen to me. After 35 years of doing this, I would say it's probably a year plus to get to a plan. Once the plan's on file, it will then go out to vote. Creditors get to vote on it. And then the plan will have a payment program. The payment program may keep the business going and just recharacterize the debt a little bit. Or it may liquidate some properties, pay some people off. It may propose a substantive consolidation, which depending on who I represent, we'll have to look at what position we want to take on that, if it's beneficial or not. That's really about it, and I'll open it up to questions, which I'm sure you guys have plenty. Yes?
If the majority of us will go for your services, can that be called a class action lawsuit?
It wouldn't be, we don't do litigation, so it's not a,
Yeah. The question was, would this be a class action lawsuit? If everyone said, hey, we need your help us.
no, I would actually be representing each of you as an individual creditor in the case to make sure what I would be doing is looking at your documents first to see if they're secured. Some of you, and I forgot to touch on this, and I apologize, some of you put money in right before the filing of the case.
Yes.
Okay. Now, fortunately, this is an interesting choice of forums because why did they file in Delaware when they're local? Delaware courts, first of all, Delaware is more business friendly on general principle. The courts are a little bit more business friendly, which is probably what the principals were concerned about. The courts, bankruptcy courts are a little bit more business friendly. But the benefit is actually there's something called an equitable lien. So, for example, if one of you turns out you put money in right before, and we can trace the money that was still there when they filed the case, we can, even if you're unsecured, we can argue that that's an equitable lien imposed. And actually, Delaware law is more favorable for that argument than the law in the Ninth Circuit where we're at. So, yeah, I'd be looking at the documents and then taking positions in the case. To the extent that my client is aligned with the committee, we'll let the committee do the work, obviously, and help them and support them. But there's going to be positions which I may take in the case on your behalf. There are economies of scales, because, and that's why you're all sitting in a group rather than me representing one person. It doesn't make sense. If you got $25,000 in the case, how much are you going to pay a lawyer? It doesn't make sense. And the amount I've got to review for your $25,000 investment is going to be the same amount of work I got to do for a somebody that's got a $500,000 investment. So with a large enough group, the way we figured, I'm trying to figure out what was fair. The way we've come up with the proposal has been to do the lesser of 1% of your investment or $1,500 cap, okay, and for a retainer. How much it's ultimately going to run is going to depend on how many people we get to support.
$1,500 cap for a retainer?
Yeah. I would say the aggregate and the fees in this case are probably going to be, for my role, probably depends on the number of everybody signed up. I'd probably say somewhere between 75 and 100 grand. But
Sandy, is that from beginning to end?
yeah. Because our role is going to be basically looking at the documentation, determining whether it's secured, and maybe bringing actions for equitable liens to the extent that we can, and then, of course, taking positions in the case. And I also, don't charge, if I'm sitting on an airplane going to Delaware, I'm not charging you for it. It's because it's not what you bill, it's how you bill. The other thing is we have a Delaware office, and one of my partners will take a lot of the hearings. How should I go? Why don't you call on the question so I don't...
Okay, and I'll try to repeat the questions. We got two questions right here. Mario, what's your question?
Well, I'm probably the last guy that should be involved in this. I'm 94 years old. It took me a lifetime to accumulate this money.
Yeah.
It's very painful to lose it. Now, I can't believe that the stock market is going crazy. Real estate in California is way up, and we're bankrupt. Something doesn't connect with me. I don't understand lawyer talk. What I get from this is what you're suggesting is that we hire you to represent us to protect what interests we have. I have no good memories dealing with lawyers. You mentioned a small fee of $100,000, but what percentage? I've seen lawyers, all of us have seen lawyers. You get a $10 win and the lawyers take $8,000 and you get two back. So I'm not very happy. Hopefully, we can resolve this. And my feeling is, I trust Rick Miller. This is all over my head, I assure you. I'm not a lawyer. I don't understand lawyer talk. But I hope we resolve this. And like I told Rick the other day, my concern is, we're gonna lose it all. And he said, no, we're not gonna lose it all. And you're telling me that to retain what we have, we should retain you as our representative. Am I correct?
I'm telling you, you should retain somebody.
So, well, somebody
I
with
would love to
primary.
represent you, but yes.
Yeah, okay, that's all I have to say.
So do most of you guys hear that? Well, Memorial feels like all my clients. We wish we never knew who Woodbridge was. You don't have to be 94 years old to feel that way today. I totally agree with you. Memorial, this is way above my pay grade too. But I think this gets complex in terms of how you do the proof of claim. And everybody sitting here could be in a uniquely different situation based upon whether you came in at the tail end or whether you're secured, whether you're unsecured, whether the property has equity, the property doesn't, because there's 138 properties out there. So I'll wrap up the gist of what you guys can decide on, whether you like Sandy's approach and his expertise or you want to pass. It's totally up to everybody.
Rick?
Do we have another question though?
Before we move on,
Yeah.
let me address one thing about
Yeah.
this. I don't think I'm basing this on experience. As I said, there's going to be schedules of assets and liabilities, and those will have values and how much the debt is, and which entities have what values. And without that, right now, I'm throwing darts in the wind because I don't know what to do. But I can tell you from my experience, you have real estate here in a good real estate market. So the chances that you're going to get nothing is not very high. I think it's high that you will get a pretty sizable return in this case. The other thing, it may take a little while, and you may have to be patient because it's going to take a while to sort this out. This filing didn't occur because of an insolvency issue. This filing looks like it occurred because the Securities and Exchange Commission was going after them to appoint a receiver, and they didn't want to get a receiver appointed, so they ended up filing the bankruptcy to try to keep some semblance of control and reorganize. So that was the reason for this filing that appears. And I haven't seen it in the documents, but I have not seen anything else to indicate to me that there's any other reason for the filing.
Question right here. Question right here.
I didn't quite, I heard the words and it's important, but English, please.
Many cases file, excuse me, many cases file because I have cash flow problem. I can't meet my obligations as they come due. Or our case files because I don't have any assets, there's no value anymore. That doesn't look like it's the case here. What it looks like is the SEC was going after them suddenly. And now, SEC investigations take place all the time on a state-by-state basis. But it looked like the SEC was clamping down on them and were threatening to appoint a receiver. And they filed this case to try to keep some sense of control. That's why I said the CRO was involved to avoid a trustee getting appointed. And that was the big, huge fight in the beginning of the case, right off the bat. And there was a little bit of horse trading. And successfully, the debtor was able to fend off having a trustee appointed by cutting a deal.
Yeah. Let's do this question right here real quick.
Yeah, so I have a few questions. So I know
Can you ask
that-
us one right now? Because we got a lot of people.
Okay.
We'll go around. We're not leaving.
I'll double back. Yeah,
We'll
I've got
double back. We got time.
Okay, because they file on the 5th, and it's been 30 days, so I know there's got to be some notice of default that's got to be filed, either individually or by somebody, right? That's what's in the contract. You get if they don't pay an interest or dividend within the 30 days, that's got to be filed.
Yeah, the question here is the promissory note information and the deeds that you guys have, because you've got several sources of documents here that's supposed to secure your money, is that you, as someone loaning money to Woodbridge on a piece of property, have to procure that, in lack of simple words, right, to initiate, like, they're behind on their payment statement, is what he's saying. He says, we got to take action to protect our interest by, like, a notification of, like, we're going to do a foreclosure.
Well, one of the things you're going to need to do is file what they call a proof of claim. You can't just give a default notice now, and the reason is once the case files, there's an automatic, what they call an automatic stay, an automatic injunction, which prevents you from going forward. You have to
Okay.
get relief from it. And the whole basis for that is, despite the fact that I agree with you, I don't like most lawyers either. One of the reasons I do bankruptcy is most of us folks are business people. We're trying to get a business deal done that makes sense for the whole group.
Yeah,
So,
I have a question.
We'll just
but
finish
there
with
are
Charlie.
things you can do, which is to file a proof of claim, which you should do.
And would they be releasing the 1099?
Yeah, that's
Dividends?
crucial.
Yeah, yes, they should do that, absolutely.
Wait, the question was about a 1099, what do you mean by that?
They should issue 1099s at the end of the,
What, for interest paid during the year?
right.
Yeah.
Well, for interest already paid.
Yes.
Correct.
But interest that hasn't been paid wouldn't get a
No,
1099.
no, no.
Okay.
Okay.
We had another
Sorry.
question right over here, Charlie.
Yeah, you mentioned 3 new people were gonna be added to this commission at some point. This is,
Committee.
No, the board of directors.
to the directors, that's what I was concerned
Yeah,
about.
I think they are actually, they named them in the term sheet.
Okay, and this is why you're involved, is to keep this out payment to these folks down, is that correct?
Well, it's one of the purposes, but the other purpose is to look at, are you secured? And
Right.
are you in an entity that's got a piece of property? Let me give you an example. If an entity X has $1 million value, and your security interest is valid, and you've got $1 million
Right.
lien against that, we could go in and try to get relief from stay and
Yeah.
say, hey, this is no benefit to the bankruptcy estate, let us foreclose on it.
Yeah, so the
It's
concern
one of the
is,
things I'd be looking at.
they're not paying any money out now because of this.
Bankruptcy
Bankruptcy.
This type of-
There was some discussion about resuming, which is good news, but frankly, I don't know how they're planning on doing
But
this.
they're still paying themselves their salaries. And they've added 3 new people. And I understand by the way you said it, that your purpose in this case is to keep that kind of stuff down so that doesn't continue to
As
be
much as possible.
be the issue.
You know, it is absolutely galling, I know, and I've been on both sides of this, to sit there and have a principal that you think took your money and did wrong and gets paid on an ongoing basis.
Yeah.
I've literally been in a case, in fact, the creditors committee counsel in a case where I was called up, I was representing one of the creditor constituency, and they were representing the debtor, and there's a lawyer, and the guy was going to Hawaii and taking $60,000 a month vacations, and had a $30,000 a month clothing budget, and I called up and I go, hey, Jim, come on, give me a break here.
Will they still be paying themselves their annual bonuses?
I don't know, I have to look at what the employment thing, and I can answer that if I look at what the employment
Yeah.
contracts, I don't know at this point.
And
because I
you
really
haven't had time
studied
to
it.
do that.
But what I was getting to, in the beginning of the case, it is sometimes having the guy that's the old owner in the case is a little bit helpful in the case because know where it's going rather than reinventing the wheel.
Yeah.
But again, you know, your questions are great because it's a concern. You're adding an entire layer of more cost on.
Right, and it continues to leak the longer and longer it goes on.
Yeah. Let's have a question back here, right here. Yes, yeah.
I'd like to defer to my husband.
Okay, your husband.
Uh-oh.
You know, after 50 years married, we speak to each other.
Okay.
And to each other. Okay, on the first page of this review document, it talks about adequate protection property. So as I go through here, that's what I have. What does that mean?
I don't know what document you're looking at, so I can't
It's
tell.
the initial paperwork that's got the 60-some pages, double-sided, small print, footnotes. And they list properties, they list people's names or the titling of their note and the dollar amount in the right-hand
This is the
column.
what document you got when you made the loan?
No, this is with the bankruptcy. This is the first initial document. Let's let Sandy say. Sandy, you've seen this before. It's the court. You've seen this
This
before.
thing.
What he's asking, Sandy, he's asking in the back here.
Oh, this is the DIP financing motion.
See all these, see the property with the people's names here? He's saying, does that mean that, like, his question is, am I secure?
It's on the front page, it says adequate protection. I have that.
No, adequate protection.
Those other ones that are listed are not adequate.
Okay, here's what adequate protection means. Let's make it simple. The debtor borrows, Woodbridge borrows $100. what's happening when they're getting DIP financing loan, debtor in possession financing, that loan, because who wants to loan more money to a debtor, gets slotted ahead of everybody. In order to make sure that if you've got a valid security interest in the junior position to that, if the debtor's borrowing $100 and pays it to Shapiro, that didn't benefit the bankruptcy estate, and as a consequence, it dilutes your interest. So they have to give you some form of adequate protection for it, either in the form of a lien against something else, or the money has to be used for a specific purpose. Now, there's been a couple of interims. The final financing has been objected to. And I don't believe there's been a resolution on that yet. However, it's important, but if you're not secured, you have to have a valid security interest in the first place to have that have any meaning. And
So that's what that means.
that, yeah.
Cindy, you had a question over here, Cindy?
Well, they did a really nice job on this. It's out to you
Yeah,
guys. The same sheet.
Cindy, go ahead.
I'm sure everybody has here, we all have different amounts invested. Is there is it prudence for everybody to file a claim? Or is there a minimum that,
No, you should, you know what, even if in chapter
Let me repeat the
11,
question, let me repeat the question. So the question was, many of you have different amounts of money in this transaction. Some of you a lot of money, and some of you the minimum 25. And the question was, well, based on how much money you put in, does that change any of the dynamics for you as a note holder?
in chapter 11, if they list you, and again, we don't know if they've listed you or not, right, because we don't have the schedule. But if they list you in the proper amount, and they don't list you as disputed, contingent, or unliquidated, which is a little box, then you don't have to file a claim. Having said that, file a claim.
Wait, can you
Better.
say that again?
Say that again, Sandy.
In chapter 11, if you're listed in the correct amount, and this is, remember, the correct amount as of the petition date, this is pre-petition claims. Whether you get post-petition interest or not is a wholly different issue. Pre-petition, up to the date of filing, you're going to have interest. I haven't looked at the notes in depth yet, but there may be default interest in there that may be calculated in. You have to look at the claim. If it's listed in the proper amount, and there's a little section that says disputed, contingent, or unliquidated. If any of those boxes are checked, that means you have to file a claim. If those disputed, contingent, or unliquidated.
Dr. Orlando, you had a question?
Yeah, I was just wondering, since we're on almost to the tail and we have unsecured, so we don't have any title or anything like that. Because when we went to Rick, he told us that we will be on first title on any property that they buy, okay? But we were never informed that that was the case, because when we gave the money, they're not even buy the property yet.
Let me hear that. Some of you put money into the Woodbridge program, and the real estate you were going to be placed in didn't get funded. And they said, do you want your money back, or should we just keep you on the list? We'll pay you the interest, and we'll put you on the RCP list for the next property we find. Some of you came in the tail end, didn't get put on anything. You thought you were going on this property, and they filed a bankruptcy. But in either case, the question, Orlando, was if you came at the tail end and you're not on a piece of property, what's the question?
Now, be honest with me, can I get anything back or not at all?
Oh, be honest with me, can I get anything back? Yes, tell me the
Okay,
truth.
the answer is, first of all, you might be secured. I have to look at the documentation. I will tell you, one particular document that was shown to me had a valid note, a valid security interest, was recorded. The problem is, and this is a little bit complex, and the reason I'm pausing is I'm trying not to make it complicated. How you perfect that interest under the law depends on what your collateral is. If your collateral is the property, it needs to be recorded against the property. If your collateral is the note, it needs to be recorded in the financing office. I don't know what they recorded and what they didn't. I can't tell you what the one document I looked at was recorded in the county recorder's office, but it was in the wrong state. So that's not properly perfected. Now, you're secured as against the debtor, and the problem is in bankruptcy, it might be arguably unsecured. However, on the people that put their money in and it never got dispersed and were waiting around, if we can trace that money, you can argue an equitable lien on that money. So each of you are going to be in a different position, and that's why you got to look at your documents and don't naturally assume you're not getting anything, because I'm telling you, I'm representing people right now that made that assumption, and everybody got paid 100 cents. So file a claim, even if you don't hire me, file a claim, and make sure you follow through. And I would definitely talk to a lawyer to take a look at your documents. Just because somebody says you're unsecured doesn't mean you're unsecured, and that's going to be the fight in the case. The other thing that may happen in the case, you've got 9,000 note holders. It's going to cost a lot of money to litigate 9,000 claims, and at some point in time there may be a deal cut, which is, I'm sure, one of the reasons why they wanted to file a case. You're better off without a trustee in the case, because the trustee would probably take the blanket position, you're unsecured, whereas the debtor or the committees, we may cut a deal, and they're incentivized to try to do a deal here. At the end of the day, even if you're unsecured, if your value of your property that you're in is very valuable, and it's $100 you're very skeptical, but I've been in a lot of cases. I'm doing this for 35 years. I'm telling you, there's distributions in cases. So I don't think you're going to get zero in this case.
In the far back, yes.
I have a question.
Yeah.
Okay, my question is this, from everything that I've been hearing, so I guess I want to ascertain, I want to get rid. So I'm going to need I need to file a claim. No one's going to file it for me. I'm going to do the filing of the claim either by retaining an attorney, right? Is that correct?
The question is, in order to make sure that I'm in the best position to get all my money back, or at least most of it, I need to file some paper called proof of claim. Yes, that's true. You can do it yourself. I personally wouldn't do it myself. I would seek counsel.
There is a form, there is an actual form for the proof of claim.
Yeah.
It's easy to download, and frankly, if you don't want to retain us and you want it, I'll send it to you. But I would talk to your lawyer. I mean, even if it's not me, I would definitely have somebody fill it out for you, because you've got to put documentation behind it. You want to check the right box. Frankly, if I'm filing them right now, I'm filing them all as secured claims. The two people that ended up agreeing to be unsecured note holders on the creditors committee, both of those guys were unrepresented by counsel. And that was a big, huge argument that people were making about that creditors committee. Because the people that were there that were represented by counsel didn't agree to do that. And when these folks asked me, and I don't have any relationship with these guys, I was brought in to consult with, they called me and said, should I be advising my folks to get on the unsecured creditors committee? What was my advice? Absolutely not.
How soon, and will I be recovering the money that I put in and the interest that I was supposed to get at the end of interest?
So the three questions. The first question is, how soon would this take? Will I get all my principal back? Will I be entitled to all and get all my interest as well?
How soon can you file?
The proof of claim? I don't know if a bar date has been set yet. People have told me March. I haven't.
March.
Is the bar date?
They have
The reason I'm surprised about that is without having schedules on file, it's kind of it's strange that they would be having a bar date, unless it was automatically set and they may extend it. I don't know the answer as I'm standing here, but I can find that out for you. And
Sandy's simply explaining that it would be unusual to have a bar date when you don't have a list of all the assets and all the liabilities.
When would you file?
So that's how it would
why
work.
would I file
When would you file?
a claim? I'd do it right away. I mean, there's no harm in you filing a claim.
And his position was to file secured.
So, and I would also want to look at the documents. I'm giving you, here's free legal advice, okay? You want to look at the documents. If there's a default rate of interest,
There it is.
okay, then I would actually calculate into the default rate at the point in time, at least when the CRO got hired. They may argue it, but so what? There's a sound basis for doing it. You don't want to file a false claim. Critically important. Don't put numbers in there that have no basis, because there's a penalty for that under the law.
I just want my money back plus the interest.
I don't blame you. You know what? That's why we're here.
Just the interest, goodbye. Just get
And if I can answer that question, is how much you're getting and when it's going to come, you should definitely hire me, because I would be the best bankruptcy lawyer in the world. But it's too early to tell right now. But I am telling. Look, as I said, I don't do any other law. I can't answer any other question with bankruptcy, but after 35 years of doing this, I am going to be shocked if you guys don't get substantial distribution. And why? Because I'm looking at assets in a vigorous real estate market. Now, I went through a case in Namco where one of the big fights in the case was when to sell the asset, because we were in a terrible real estate market when that case got filed. And properties were liquidated for sums of money that we would have gotten twice the recovery if we liquidated them today. So,
Joe Spina?
We're one of those investors that came in mid-October. Our check was cashed, but we never were listed on the property that we were supposedly investing in. Does that mean that I'm an unsecured investor, or it all depends where they're holding the money and if that money was even put to that property?
your second part of your question answered your first part of your question. Yes, it depends on where the money was put. If the money's there,
Or I don't want to assume.
so we might be able to take a position. That's the equitable lien argument.
So the question was, once again, I wasn't assigned a piece of property, and I didn't get any sort of documentation to prove that I had a trustee note against that property. And so I went in relatively late, close to the time they filed the bankruptcy. And so, did you guys hear Sandy's answer to that again? Could you say it again, Sandy?
If you were very close to the bankruptcy and that money was sitting there and undistributed, you might be able to argue for an equitable lien. In fact, in the proof of claim, if that were the case, after looking at the documents, I would take that position in the proof of claim.
Now, Sandy, does that put you up high in the pecking order?
Well, secured creditor is always better, but again, unsecured's not the end of the world if the value of the property is there. Okay? So if, for example, remember how they structured these things is my understanding, there's a piece of property that was a first deed of trust, and then they assigned out interest